I'm in the business of protecting intellectual property, which is your currency as a business owner, especially in AI or technology. When you have developed something, your currency is actually the idea, which includes the implementation of the idea, any secret sauce, which would be trade secrets, any authorship of things that content that you produce, that you have authorship, that's copyright. But usually in AI, the major thing you're concerned with is patents. And so I'm just going to kind of go through here a little bit. That's what my company's about. I mean, I'll send these slides to Seth, so I'm not going to go through that. I want to get to the points that we need for our 10 minutes. But in this, one of the things I do, I serve as a network advisor or company or firm to TEDCO, and what that means is that we provide intellectual property insights for up to 2 hours pro bono or courtesy to any TEDCO members or TEDCO companies. And we do that to encourage innovation in Maryland. And because a lot of times if you're a startup, if you're in an incubator or one of these Maryland innovation centers, you are bootstrapping or you have limited resources, and you need to know, how do I invest in or protect my idea? You know, if it hasn't actually become something I can sell yet, how am I able to protect it? So investing in intellectual property is crucial when you're a startup, because it hedges or protects your technology. Sometimes when you're undercapitalized, you're not in a position where you can actually use other means to kind of protect your ideas. It gives you something that that has value even before your idea is fully implemented. So that's a team of us. This is most of us. We have a patent attorney. I'm a patent agent. We have several other analysts, former patent examiners, and that's why we use the term patent insider, because all of our professionals have minimum of 10 years in the business, either inside the government or outside, but advising from all different types of matters. And one of the specialties that we have is intellectual property is software and AI. Again, like I said, I'll send this to Seth, so no need to go through all the details. This is how you can connect. But what do you need a patent for? So this is really big. These are statutes. So the Constitution guarantees intellectual property protection for anyone who invents or discovers any new and useful process, machine, article of manufacture, or composition of matter, or any new and useful improvement thereof. And if you meet this criteria, then you are able to get a patent. And so these statutes, this thing is called a 101. Is your invention statutory? So the big question about AI, as we'll see, is whether or not AI constitutes something that is tangible, whether it constitutes something that is one of these statutory categories of invention. So that's the law has to always be reinterpreted based on the technology, and sometimes technology, and most times technology moves much faster than the law. So the two things that you need to get a patent, if you meet that threshold, number one, is you have to have an invention that is novel, and then that is non-obvious. When I say novelty, it means it has to be this terminology here that says any new and useful improvement thereof. That's what novelty is. You have to have something that's either new, meaning it's never been done before, or something that's a useful improvement of something that has been done, but you're improving or iterating. And this is also important when you're dealing with software or machine learning. You may be using, you know, a library. You may be using a GitHub, library as your basis or foundation. You may be using a software as a basis, and you have a new implementation. So that new implementation could possibly be patentable. But the actual, you know, if you're using anything that's open source, or you're building on top of a software development kit or something like that, then the basis of that kit is not, you know, it's not patentable, but your implementation can be. So this is why you can have apps built with different codes, and the app, you know, there are ways to find patentable uses for it in a way it can be drafted for a patent. So the other thing is it has to be non-obvious. It means that you can't just take something, let's say you find a way to automate signature. Let's do something that says, okay, let's do something that's well known right now. We'll just pretend it hasn't been invented yet. But think about, like, say you created a way to search images, and you did this before Google came into existence, before there was any type of image searching software. So to be non-obvious would mean that if we take the status quo that Google image search already exists, you couldn't just say, well, I changed the interface window. I took the interface window from, say, another crawler and from Bing, and I used it, integrated it with what Google already offers. You've just simply put two platforms together, and you haven't changed any functionality. So that's obvious. It's obvious because you're using things that functionally already work, and you just put them together. To be non-obvious, it means that in that combination, there has to be something that's new or a useful improvement. So I hope that makes sense. And for time, I don't want to go too much further with that. We can deal with that in the questions. So what patent rights are and what they aren't. Patent rights are rights to exclude others from the use of the invention, but it's not an exclusive right for you to use it. Others can use it. They just have to license the rights from you, but you cannot prevent others' use of your invention. You can only, when it says right to exclude from use, you can exclude people that don't pay your licensing fee, or you can sue them and you can enforce it. But it doesn't give you exclusive rights like you're the only person that can use it, meaning that I'm the only one that can use this technology. The reason that you get a patent is that it's public. You publish it in exchange for public use of your technology that advances the collective technology for the public. And for that reason, you have the right to exclude others from use of the invention without meeting a threshold or a standard of paying a licensing fee. And you can enforce it against infringers. But it's not, you can't say I made this and I'm the only one in the world that will ever use it. That's not what a patent is. So a big thing that I think would when talking to Seth and preparing this was just one thing that's not touched on is we can go into the weeds of in the examples or in the conversation about what a patent is and what it looks like and what are some examples of AI patents that have been published or that have been granted. What do they look like? What are they doing? How are they approaching it? But one thing that's not talked about is, so I get a patent, so what? How do you monetize it? And I think this is something people know it's important, but they're told to get a patent, but the question is, so what do I do with it when I have it? What's the value? So monetizing a patent is you have to understand that process, and a lot of times, I guess a way to look at it, and we'll go through this, briefly. And Seth, let me know how I'm doing this time. So the main thing is that you can make money by selling your product, or selling your patent, or licensing your patent, or using your patent to leverage VC investment, but that always comes with strings, or taking a loan out against your patent. So selling it, that's pretty straightforward. You have a patent and you just sell your product. And you say basically your selling point is your products are unique and they're backed by your patent. And you basically have to, it's a DIY kind of situation. But it can be cost prohibitive if you're a startup. And so some people think, this is the only way to go, but usually it's a combination of this and something else to really get value out of the patent. And I guess this is prefaced by the patent has to be something valuable. It can't just be a widget that is only useful in your own mind. There has to be users or a market or some type of proof of value in the marketplace. So selling your patent, you can, basically hire a patent broker, which is like a real estate agent for housing. If there's a listing, there's marketing, and there's closing. It's just like buying a house. I mean, that's the closest analogy. I mean, there's some other, there's some other factors that are a little different, but for the most part, generically speaking, broadly speaking, it's like buying a house. So you get an agent, a broker, you list it with investors, and there are companies, there are hedge funds that basically invest in patents as part of their portfolios. There are private companies and others. And so the main thing is to, if you have the relationships and you are connected to some VC or investment capital, this may be a way to go as well. Another way is selling it with a license back. So this allows you to maintain your patent rights for your use. You can sell your product, you can manufacture your product, but you no longer have the ability to assign your patent rights to others. You're basically only selling enforcement rights. So someone says, okay, you have a hot product, I want to buy the ability to enforce this patent. I want to buy the ability basically to sue people, or I want to buy the ability to basically become your competitor and prevent others from competing with me. And then selling it with the revenue share. So this is basically like give you some cash now and cash tomorrow. And you're basically brokering with someone that's going to, usually some investment capital, that's going to basically based on performance of your product in the market. And I want to preface all this by saying that this is based on so that you're leveraging something that has value in the marketplace. So a lot of times people think just getting a patent in and of itself is the win, but the patent only protects something that is marketable or has demonstrated some type of revenue. For example, the USPTO, the patent office is part of the Department of Commerce. So it's the whole purpose of getting a patent is to give you something that's a cash engine for the economy. And so you have to, the value of the patent is demonstrated by actually having a market performance of generating revenue. And so when you do that, then a lot of these things we're talking about as far as selling your patent come into play. People aren't going to necessarily buy it. I mean, there are a few firms that do that, but for the most part, they're going to buy something that's valuable. So think of Shark Tank. If you've ever seen an episode of Shark Tank, they want to know how many users do you have, how much money have you made. The same kind of questions are going to be in any of these. And finally, licensing. Licensing your patent rights to a manufacturer for a share revenue stream. This is usually done if you don't have any capital up front. Sometimes if you have physical products, less done in the software, unless you're going to white label a product for a larger software company. But usually they just buy you outright. This is what happened with Instagram. They were bought outright. So you can, if you have stock, licensing may not be, as attractive an option if you're looking for a buyout. But if not, you want to maintain your rights, then you license your rights to a manufacturer or in this case, a software company for a share of revenue, and they'll usually give you a very low, if not, minimal upfront payment, and then they'll give you, revenue on the back end once they've started to generate income or revenue from sales of your product after it's being manufactured. So, this is the last one. So VC investment with strings. The VC investment is VC investment, like Y Combinator, any of these things that you've seen or heard about. And the major thing here is just this is strings attached. You're always going to have, for instance, a big thing with a lot of software companies and software startups. When this COVID-19 happened and the Small Business Administration is administering the PPP, or the Payment Protection Plan, a lot of startups that had VC investment, even though they were identified as small businesses, because they had VC investment or VC members on their boards, they were by association considered to be part of the larger companies. And so they were blocked out of a lot of this financial investment. So that's something important to know. If you're a startup, when you receive this, there are pluses and minuses to receiving VC investment. More than likely, any outside investor that's not part of your original VC, they're going to be discouraged from further investment. They're going to say, go back to the same people they invested the first time. Exhaust that investment before you get more. So it's just something to consider. Let's see. Also, loans, we talked about that a little bit. It's pretty much like getting a mortgage. You have a valuation, which is like an appraisal of your patent. Or you get an appraisal of your house. This is like an appraisal of your patent. And it's based on market studies. It's just like it's an accounting practice. It's a very, very, very intensive, and I have a sample evaluation I can show you later. I think I'm at my time, Seth. the thing to drive home in the whole patent process, regardless of whether you talk to someone like me or someone else, the process is the process. The process doesn't change. And the thing that a lot of times that in my experience, like I said, 14 years in this, 10 years inside the government, 4 years outside, working with startups a lot and working with a lot of bootstrapping startups and some funded startups, working with also some contractors and more established companies. The thing that I think the biggest challenge or thing that I see that comes up most frequently is that people think it's like set and forget. I can set it and forget it. I can pay a patent firm, I can pay my attorney, I can pay my agent, I can tell them, I want a patent on this, and then I can go do something else. That's partially true, but you are the driving captain of the ship. There are many times that, think about it. Again, I'm going back to the real estate example just because it's something that's very accessible and common for most people, is that, your realtor works for you. They're only as good as the information you give them, and they're only, they're ready to sign off on any house. For those of us who are practitioners, we see, tens of, hundreds of patents a month in our research and in our work. So it is valuable, but for us, you have to be involved in the process to really get the true value. So that if we draft a patent and you don't review it and you say, well, it doesn't really cover what's important. Well, you didn't tell me that. And so these are things that I see that come up where there's someone is paid for something, set and forget, and then when they come up on their evaluation and they're looking to go on Y Combinator and their patent's evaluated, they realize it's not worth anything. And it doesn't really cover what they're actually trying to get. And so they've exposed their IP, but it was never protected because they didn't really participate in the process. You don't want that to happen. So you have to start by doing your own due diligence. There's these websites, Google Patents and Free Patents Online. You can start doing free research by yourself before hiring a professional so you can just get an idea of what's out there. And then hire a professional. Don't do it yourself. That's the other thing that I see is that people say for financial reasons, let's try to see if we can just do this on the cheap. And then you end up with the same thing when you actually need the intellectual property protection. What you have is not valuable. And then don't let lack of capital make you lose out on IP. There are very strategic ways that you can start today, even with a small budget, to protect things that are valuable and have a plan for the future. But you have to have a plan. You can't just say, well, I'll get it when I need it, because you may have done some things that prevent you from getting it.
Tariq,
and you have to use the, yes.
Maybe I can ask you a question. I think that there's a lot of uncertainty, especially among very early stage startups, about whether they actually have something that is protectable. For instance, we do have a question, and I'll enable the person who asked it in a moment, about whether a particular approach with machine learning is patentable. How do you figure out whether what you have is protectable? And for instance, you work as a TEDCO network advisor. Do you advise companies within the TEDCO orbit about whether, take a quick look, advise them whether what they have is protectable? How do you even figure out if what you have is protectable?
That's a great question, Seth. So this is being a former patent examiner. I worked at the office. I approved applications for patents. So basically, I went through a process of assessing whether or not what this person has applied for is actually going to be a patent. Is it even possible? A lot of times companies don't take that step because they're like, well, I just need to get a patent for this and we'll figure the rest out later. Before you invest the time, the resources, a patent takes 3 to 5 years unless you expedite. If you expedite it and pay the extra money, you're looking at 18 months on average. But that's still quite a lot of time and money and investment and resources. So what we always recommend is doing what's called a patentability search and assessment. So the patentability search and assessment is you have to break down your idea to its component parts and then search those parts against what's already out there. Because again, remember the things that it has to be statutory, novel, and non-obvious. Statutory means that it has to be something that is one of the categories of invention that are eligible to get patented. The novelty aspect means that it has to be new. Now you can look at we're not as a patent office, we're not, for the most part, 90% of what the examiner looks at is publicly available. there are unpublished applications that we have access to inside the patent office that is, no one in the public will have access to that. So that's additional information. But for the most part, everything that they're going to look at when you file a patent, you can actually look at before you file. So when you want to engage, a professional to at least do, and this is what we do as TechCo, as a network advisor, I don't do the full extent because you only get 2 hours, so I do within 2 hours a patentability search and assessment. A full one might take me 20 or 30 hours depending on the complexity. For AI stuff, this is more like that level of work for our team to deal with. But basically, that assessment is going to give you two things. It's going to tell you, number one, did somebody do this already just like I'm doing it? Number two is, if that's not the case, which usually, because software, well, just any patent, but usually software solutions are based on problems that are shared. People are experiencing problems with a certain type of technology or a certain type of issue, and they're looking for a software solution. And so usually there are multiple solutions, but they're usually different. And so you can sort through, you need to know what's already been done. And usually people say, well, it's not on the market. But what's on the market doesn't mean it hasn't been applied for a patent. It hasn't been published in, MIT's graduate school research or another R&D lab. It doesn't mean that some blogger, some enthusiast in Europe somewhere in Asia has not published something on the internet. So I think these things are very important. And so I hope does that answer your question, Seth?
Yeah. So let me introduce one follow-up. Then I'm going to call on Rob, who's one of the participants. Rob, there are two Robs. This is the first one. If you unmute yourself, and if you are up to it, turn your video camera on, and you can ask your question live. Just give me a second, though. So I was wondering about a lot of us in the artificial intelligence world, what we're dealing with is methods. Tariq, you already talked about people who are building on top of some open source library or a platform. I suppose that could include things like Microsoft Cortana, Amazon SageMaker, Google Cloud AI. You talked about that. A lot of what we're doing, a lot of our intellectual property is related to methods and procedures, processes. Could be for data collection, model building, product or service design, and so on. Rob, you had a question about a particular aspect of that, so why don't you go ahead with your question?
Hi, can everybody hear me?
Yes.
Okay.
Yeah.
Sorry, I don't have video on my end. So you kind of addressed this with answering Seth's question, but this gets more into the details of like what exactly qualifies as the differences and what qualifies as novel. So my question was, let's say I'm building a machine learning product and let's continue with the example that we had earlier of like searching for video or images, right? You want to do an image search. So let's say I build a machine learning program to do that. I use the same library, let's say TensorFlow, or just for the sake of argument, as a competitor. But I train my model on, say, maybe some of the same data sets, but not exactly. Or even if I do train it on the same data set, I get different weights for my inputs. I get different numbers of layers and nodes. Like the implementation details, like the nitty gritty under the hood is different. So would that be patentable? Like, I guess I'm just trying to get like, what are the important differences here?
So those are very excellent questions, Rob. And I think is you RoboGrow in the chat?
No, I'm just Rob.
Okay, so there's asking some interesting questions as well.
I have a queue of questions, and we'll get to RoboGrow after the next one. Okay,
so people don't like the answer, but the reality is it depends, because for each, this is what I do as a former patent examiner, as a patent practitioner now, and what our company does. We have to take the details of each software case by case, and then I have to do a search and I have to look and see, okay, what is being patented here? Because the law is so fluid on, I guess, not implementation, but on understanding of the statutes as it applies to software, as it applies to AI. and there are presidential cases coming out on a regular basis. So we have to basically stay abreast of what's current. And then based on the current guidance, then we would apply that to the software that we're examining and looking to patent. Now, it's based on we're looking at what has been allowed. So if I can, I don't see any controls here to show stop my share and show another screen, but I don't know why. If I find that, I'll pull up. There's basically classification. Okay, there it is. Thanks, Seth. I was trying to figure out how to do that. Let me turn this off. But I'll show you. There's another. Let's see. Can I go to this? Let me go to this. I'm going to show you how basically what we do as. Okay, is this working? Why can't I see this? Do you all see another screen? So everything in the patent office is classified. And when I say classified, there is classification of, okay, here it is. So if I can pull up the screen here, there we go. This is an example. You would go, I'm looking at the European patent office. So basically, I just wrote in here this classification search that said artificial intelligence. So you'll see here, this has machine learning. Let's see how specific it can get. We look at machine learning. We can really drill down. Let's say we click on that. So it goes down to the kernel methods, ensemble learning. Let's say we do something, this is reading. Well, let's stay with that. Let's say knowledge model. So we can really get, very specific into, and that doesn't mean that just because the classification is specific, it doesn't mean that the examiners or the patent office actually classified them correctly. But we go through this detail and we look to see what's categorized. Then we also do text searching. Then we also do concept searching. We go through all the different databases. And then once we have that, we have a list. It could be like 1,000 hits. And then we go through that and refine it until we get what's closest to what you have. We look at the patents and we look at the things that are published. And then that informs us on the landscape of what, because the example, this works, the annotation feature here. Let me see. This might work. Okay, so imagine when you're getting a patent, like, let's say this is your yard, right? This is the yard or the land that's available. Your patent is like a stake, like think of the Wild West and you're planting a stake in the ground. So you want to get as big a stake as you can. And it's because when it's a big stake, when somebody else tries to get something here, or they have something they're getting here, well, that intersects, and this is where it's infringement. It's where you can enforce it, and it's valuable. What you don't want, a lot of times inventors will do this, they want something like this. It's very small, and you have to be very specific to even get close to that. And so it's an art more than a science, because what's being enforced and what's being interpreted changes from quarter to quarter, from court case to court case. It's a very moving target with this new technology of AI, and getting the judges, getting the legal representatives who are lawyers, and they understand words but not necessarily tech as well as the inventors. So there's a lot of stuff being decided, and hopefully legislation will change the interpretation of the law that's more favorable. But right now, method patents and software patents are some of I would say that the threshold of getting a patent there is much higher than, say, something like a widget that's going to be sold on Amazon or something. I hope that answers your question.
It kind of does. I guess I just saw, like, when we were at the top of this list, it said support vector machines, and kind of the impetus for my question was the fact that there's a number of frameworks out there for doing machine learning, but almost nobody is rolling their own. Like, people aren't just writing their own version of TensorFlow. Like, that's reinventing the wheel, and that's kind of antithetical to the tech field. So that's why I was asking about like the weights and the number of nodes and layers, because that seems like that's the actual heart of the thing, but it seems like it's still very fluid.
Let me, Tariq, before you answer, I'm going to call on Anastasia. You had a somewhat, to me, similar question about integrating multiple individual parts. Do you want to pursue that one, Anastasia? You just unmute yourself and you can go ahead.
Okay. First of all, I'm really enjoying this discussion. I think my question is very simple, and I'm a little nervous that I'm going to get it. It depends. But I'm imagining there are 5 different pieces, so 5 different building blocks, which in and of themselves function in a certain way, and in fact have been validated as such. And one takes these 5 building blocks and integrates them into one platform of those 5 individual blocks. If you do that, I think the expectation is, yeah, you should have something that's akin to a hybrid that will have all 5 properties integrated into one. Does that make it obvious? And is the value there really in the final platform or in how you put those pieces together? Which then goes back to Rob's question, which is, if it's just in how I did it and I put it together, then am I not better off just having it as a trade secret?
So that's 3 very important questions. And let me answer the last question. No, it's good. Let me answer the last question first. So a trade secret is only good for software if there's no way that it can be reverse engineered. If there's no way that they can go to the back end, if there's no way that they can look at the, go to your libraries or see your code, if there's no way to reverse engineer it that way and you can protect your black box, then trade secrets are awesome. But the way the tech is going, and especially with open source, if you're building on a platform, there always tend to be back ends. And so I know people that do both, where they have a patent that it just basically says I have a black box that does these things. They don't give away the black box. They give away the functions. They give away the 5 components. They say this is happening. They don't give away too much of the how. They give enough how to get the patent, but not too much so you can reverse engineer it, which is really not, you're not supposed to do a patent like that. It's supposed to tell you everything. But they do it enough, and then they also have trade secrets for the real heart of what they're doing. It's the reason that these approaches are there. This is a kind of a standard for a lot of software companies, is because the law is so fluid. And so there was a time when I first started doing this, let's say about 14 years ago, people said, don't get a software patent. It's impossible. You'll never get it. It's horrible. Don't invest in it. Do a trade secret. Don't tell anybody about it. It's worthless. Now, Apple and Google are filing, thousands of software patents a year. Thousands. Amazon, all these companies that have the cloud, or Microsoft, there are all these things that are using technology in that manner. They're finding ways to do it, and it's in one way you're creating the technology and you're advancing the IP, and that's one thing. That's what the heart of what the patent office or these protections are for, so you can be an innovator. But the challenge with that is that the law doesn't always catch up with your interpretation, and that's a challenge that I can't change no matter how I answer the question, because it's the reality. If you're truly innovating something in technology, the law or the interpretation of the law may not be there. So you have to be creative in how you protect it. So a combination of those. The second 2 questions that you had, I would like to show an example, if I could, on some things that are being patented, so you can see the different strategies that are being used. But there's a combination of strategies. There is one strategy is to, so there are companies that capture the user experience with the software, and they capture the user experience as a method. And by capturing the user experience as a method, and so it's not, it's not a phone, it's not the software, it's a user interface configured to receive, data points from, a user. And then there's a process of, based on those data points, determining a certain course of action. And then based on that determination, then providing that user or with a outcome, or providing another element of the platform with a data point to then perform some type of function. And so it is a method, but you're really writing an algorithm, but you're not writing an algorithm until it's drafted in code. You're writing it more in a conceptual way that would get by the patent office, that would meet the threshold of tangibility.
You know,
Does that make sense?
you know, we kind of come back to the same points. Oops, we kind of come back to the same points. I'm going to jump someone up the queue who is Matthew Rummel. You put in a question via the Q&A. Do you just want to ask it live? Because it's sort of just complementary to what we've been talking about the last few minutes, just to add to that. Matthew?
Trying.
Yeah, you're good.
Oh, hi. I was just wondering, because a lot of machine learning and AI is not necessarily the algorithm as opposed to the quantity of data and the quality of data and how you use your data as parameters in your application. So is something like training sets or the type of data that you have built your products on able to be patented? Thank you.
The answer is yes. And so I think this might make sense to do some, let's see if I can do this live without causing an issue. To pull up, basically, let's look at one of these classifications here and then just pull up and see what it says. So I think that's the best way to look at it, is to look at, and let me see if I can pull some patents, because I pulled publications that tells you what people are publishing. But yes, you're able to the platform itself is possible to get a patent on. I see those. The algorithm behind it is also possible. Like I said, you can quantify the user experience. Data science or managing like big data, the Internet of Things, these types of things are also data processing. These are all things that you can patent. So I want to give an example. Computer is all the steering of the
we have several more questions. So
okay.
Maybe go on to some more questions since it takes some time to bring up the examples. So the next person in the queue is Robo Grow. If you could explain what your name actually is, but in any case, if your sound is on, you expressed some skepticism in your chat comments about the possibility of small companies actually being protected, but then you had some further questions in there, trade secrets and so on.
Yes, actually my name's Peter James. Robo goes just based on some of our
Peter James,
ag
okay.
robot technology. And yeah, we have back in the 70s through the early 2000s, we had an IP, family-owned IP licensing company, and I've been to court on a lot of things. Had EchoStar Dish spend 10 times what we asked them for a license to beat down a patent, and it's really tough unless you're a VC-backed company with $10 million. But I will tell you, if you're a good poker player, patents aren't too bad of a way to go. My dad made $10 million, over $10 million on a patent. That wasn't enforceable just because he was he was a good bluffer. But it's my understanding, and maybe you can verify this, is that recent changes in the patent law have made patent applications public domain now, where they used to be hidden. And so what patent attorneys have told me is that the small guy just gets all this stuff stolen, as soon as he discloses it. So, and then plus, our technology, we develop patentable ideas like every day. So we've got hundreds or thousands of things that could be patented. And to get a good patent, you need to write good claim language. And that requires, I think, a litigator, a patent litigator, because they know how to write the claims so they don't get thrown out in court. And why isn't trade secrets, particularly if you're not letting the technology go out the door, like if you're providing services, and that's another reason why I sit there and watch our servers and have state-owned Chinese companies hacking at our servers all day long, and Russian players. So if you've got software and the AI, particularly those data sets that the other fellow mentioned, I would recommend you bone up on your security.
Tariq, your any response there? This seems to be he's a straight man for you.
Well, no, I appreciate that because it's everything you said those are things that I've seen and that clients of mine and people that in the business have experienced. There is something called willful infringement, and this is having a patent doesn't stop business from happening. It doesn't stop the risk of business. It doesn't negate the risk. It doesn't negate the shark. I mean, they have the show Shark Tank, which is very similar to some of the things we're talking about, usually not in software, but these types of, the big does eat the little mostly. Like I'll give a couple of examples just to, verbally, but willful infringement is when, these bots will, for these companies, let's say Google or Amazon, if anybody's inventing in their space, they will, look for what's published. And when it comes up, they'll either, before they would just buy you, buy the company or buy out the rights. So they didn't have to deal with the competition because it's cheaper. Or they would, now they go to patent court, which is the patent trial and appeal board, and they seek to invalidate your patent. And so that's a reality, and that's cheaper than what they would do before. But rather than buy you, they'll pay $300,000 to invalidate your patent. And if you can't fight it, then you've basically been nullified. And so that's the reality of the strategy that larger companies are using to, because what they'll do is once they invalidate you, if they can't invalidate you, then they will buy it. And it doesn't matter. You can be successful, but unless you have a war chest, you can't necessarily be a larger company. So does that mean don't get patents? It's not what it means. It means that you have to understand the landscape. And I do agree with you, Peter, about having a good litigator. I think the challenge is, and I don't necessarily think it's the litigator. Litigators don't usually write claims; they defend them. But the litigators. So what gets the claims to patent in the patent office is different than what defends them in court. That's just the nature. It's two different. If you want to say two different ballparks, you're going through bureaucratic red tape through the patent office to get a patent, and once you get a patent, then what's held those claims at the time you got them, it could have been perfect, but how they're being interpreted in court is a matter of case law, and that's evolving. And so it's just the nature of the beast. It's not necessarily something nefarious for the patent office or by the legal, the justice system or the legal system, but it's more so the nature of these two major entities of commerce and law trying to manage business. And the best thing would be if people would just be honest and say, yeah, you invented that first, let me pay you for that. But people don't do that. So we're dealing with how do you mitigate that? That's more of a personal relationship in terms of business, how we interact in terms of entities in commerce, than it is an institution of the patent office or of the legal system. And that's constantly evolving, and it always has. There are constantly patent acts in presidential cases, the Supreme Court, things like that, federal circuit, or even state courts that change how laws are interpreted. So I think this last example, I'll give this an answer because I think it's a lot of these questions are coming the same. Even the comment that says that sounds like the patent office system doesn't protect small business. So I know a gentleman who he made a widget, got a patent. At the time he got the patent, he couldn't afford a good attorney to do it. He just did what he could afford. He got a grant patent. He got it licensed. He made millions of dollars. Went on Good Morning America, did all these things. Once it got so successful, it started getting knocked off by larger manufacturers. And then, so he started fighting it. But when he went to go fight it, he realized that the patent that he had was invalidated because it was a poorly written patent. That's the reality. It's not that he got a patent and they took it from him. The patent that he had didn't really cover as much as what he thought because it was written it wasn't very well done. And so he ended up losing the patent, and then he can't enforce it. So not only did he lose the licensing battle with this competitor, but then his own company that he had, the the license agreement with renegotiated. So well, if they're not going to honor it, then we don't have to honor it. We can renegotiate our agreement. I still say that it's a win. Business is risk, but this gentleman went from whatever job he had to a multimillionaire from an idea, and he didn't lose all of it, but he definitely it didn't just go off into the sunset like a movie. And that's the reality. This is business. So the patent is not the business. Getting a patent is not going to save your business. In order to navigate these waters, like Peter, like you said, it's a very vicious. If you have something that's going to be great, then you're probably going to be challenged. And if you're going to be challenged, usually it's going to be after you've made some money. Otherwise, it's not worth challenging. So just understand that you have to, and it's hard from the tech community in this sense, because you want to do the tech work. You want to provide a solution. You're passionate about the software. You're passionate about the work, and the business is just like, oh, leave it to somebody else. But that's where all these challenges we're talking about are business challenges. They're not necessarily tech challenges or unique to software, unique to AI. They are the challenges of going from small to big and stepping into a bigger competitive market and having to deal with law and lobbying. And it's the reality of it. And it's unfortunate that it's like that, but that's the reality of business in America, actually.
So let's, this is Seth again. Let's take a question from Jared next. And then after that, Jeremy. That's the people who have flagged that they have something to say. If there's anyone else after that, would you raise your hand, please? But Jared, you have something to say.
Hi, Tariq. Thank you so much for your presentation. This is really enlightening. It's sort of also, I have to admit, a little terrifying to hear. It just feels like a bunch of mistakes that can be made that you'll pay for deeply down the road. So, but I appreciate it. So I've applied for a TEDCO grant, so I hope that I can get a free consult from you very shortly. So one of my big questions are sort of, number one is, we find ourselves, my company makes chatbots that work for lawyers and does some legal tasks for them. And what we find ourselves doing is, but just changing up your techniques all the time. I mean, the machine learning community, I think, wonderfully has created Google and Facebook actually released some of their best stuff. And folks are using that, and then they're throwing it away and they're going on to the next thing. I guess the first question is, like, it kind of feels like maybe we shouldn't be patenting at such a low level, but it feels like it would be a big waste of time and money if we were constantly patenting this stuff that we're probably gonna not use within 3 to 6 months. And then my other questions sort of have to do with the idea of publishing your ideas. One is, if you publish your idea but you haven't patented it, is the fact that you published it first protection for you? And the second is, if you publish your ideas because you want to help the greater community learn from them and you feel like you've learned a lot from others, are you actually kind of, by showing your back end, which would otherwise be hidden, are you exposing yourself to patent litigation that you wouldn't be otherwise if you were secretive and didn't share?
Yes, the answer to both questions, I think, is yes. You definitely, it's possible whenever you publish something, you still can pursue patent rights within a year of publishing something, or publicly, talking about something in a group, or in a Zoom that everybody's doing nowadays, or something like that. But if you publish, then everything that you're subject to, you're exposed. So anytime even if you put something on GitHub, and if it's usually it's not going to rise to a level of infringement where someone's going to go after you, but it's more so when it becomes commercialized. That's where the threat of infringement usually happens, because it's a commercial protection. I think the first question you asked about, for certain business models, it doesn't make sense a patent is not the way to go. So a lot of times for software companies, what is done is they copyright the code. If you ever download, an app or you have a software solution, you're running a SaaS business or something like that, they copyright the code each time it's updated, every version, or they have, when you download it, you'll see in the terms and agreements, basically, you'll see the version number, you'll see all the protections, and you'll see the legal disclaimers. So that's something that's a way that usually is done. And once you have something that rises to a level like this is consistent, this is like I'm not going to patent the modules that I'm using, but once I get to a point where I have a platform or a SaaS solution that's providing us X, Y, and Z to a client or a customer, and I'm using a plethora of modules, I don't necessarily want to patent the modules, the details of what I'm using today, and I might be using a different library tomorrow. I might be using a different service to provide that solution. But the main thing that you do want to patent is the overall. What is my customer getting when they come to my company? So it's a combination of what's called a business method patent and a software patent. So you quantify the user experience, you quantify the AI, what's happening from the input, what's being provided data-wise, what's being transformed data-wise, or what's being processed. And then you also look at, is the platform in and of itself, the way that we're communicating with these APIs or what we're doing, is that something that's, is that different? And again, you can drill down as detailed as you want. You can say, well, on the surface, it's not that different from, what most SaaS companies are doing. But if I go into the details, then this is a very specific curated solution. The question about is it worth it is more so based on commercial value. And I mean, it's like a stock in that sense. This is a paper asset. You're describing in words and pictures what software is. And based on that description and the aptitude of your draftsman or your practitioner, you have something that once you get a patent or you build a portfolio of patents to protect various aspects of your technology, then those are paper assets that increase the value, or that increase in value as your company increases in value, or as your solution gains in more and more revenue. But I think at a startup level, you want to look at what's the overall experience that I'm providing. You have to keep backing out into a broader and broader or global vision of what the actual solution you're providing is, seeing if it's something that's going to be lasting 3 to 5 years from now, because your patent is for a 20-year window. So is it going to be something that's going to be of value in 20 years, or is this like a hot ticket that's going to be 1 to 2 years and to be obsolete? Or do I have something, can I think of it broadly enough as a software solution that it's going to be something that this niche of technology is something that I can look to patent, as opposed to my current module or system that I'm using to provide X user experience or X service right now. What about the overall niche? If I'm providing solutions, let's say, to machine learning, is there a particular field of technology you're going to apply machine learning to? Are you going to do machine learning for like financial models? Are you doing machine learning for a particular type of analytics for data, for certain types of data? If you're looking for right now for COVID, for like life science data or virology, these type of things, you can put that in there and say that's the niche, and then focus on getting a patent on that as opposed to the specific modules. I hope that makes sense.
Okay. I have 2 more questioners in the queue. We have about 10 more minutes, so let's get those 2. If there's anyone after that who wants to have a short question, then would you raise your hand, please, in the Zoom raise hand feature, or send me a note. So Jeremy, you're up next. You want to pose a question, make a remark?
Sure. I just want to kind of get your thoughts on so if you have an AI technology to be patented, but that technology could possibly be weaponized, what are the greater implications of putting that in kind of like a public forum for other people to see, where they then could take that and use it adversarially against your own government?
Okay, well, that's a great question. Jeremy, I think I met you at TEDCO, one of the events, or
Yeah, we've met once or twice, I think.
yeah. Good to see you. You know, you're okay. So I think so there's certain things like DoD. When I worked, I did cryptography at the patent office. That was one of my subject areas. And to do that, like one of my supervisors had clearance, and basically, like for certain applications, I had to go through to their office, and it was hidden, like it was never published. These were like different security algorithms that were never public, but they were granted patents, but they were never public. So there are certain things like when you apply, you can say that this is an issue of national security. Or they might determine when they examine the application that it's an issue of national security. You can request to not be published. You can request to be, one of these non-disclosed patents. So it's public at the patent office, and it may be public to internal government resources. So like DoD, or they'll have access to any granted patents, but it won't be publicly accessible outside of that. So that's possible.
All right, thank you. I appreciate it.
You're welcome. All right, Chef, let me know if there's anybody else.
Okay, I think it's me. My name is Dan. Thank you, Tariq, again for sharing your time here, and Seth for organizing this. So pretty much my question is related to this fact that oftentimes, AI and machine learning is interdisciplinary, and it often is applied to some industry or some context of things. And so to keep my question as simple as possible, how much, whether it's a provisional patent examination or a patent examination in general, how much of that context is considered, such as, let's say, HIPAA compliance, or in the medical field, let's say FDA clearance, and where that particular technology is in respect to, let's say, that process of being cleared or being compliant. How much of that is even considered as part of the examination? And if so, should the applicant even kind of keep that in mind as they're applying? Thank you.
So I just want to make sure I understand. So like if someone has like a medical technology and, it can be used, will the office in their examination consider whether or not it's HIPAA compliant?
Yeah, or like situation where it's not cleared by the FDA clearly yet. So it's like a wild innovation, let's say, that claims to do some amazing thing in the medical field, novel and such. But the likelihood, let's say, in respect to FDA clearance, let's say just hypothetically, is pretty low because we don't know where it is in that process. Typically, do you advise your clients to have something like that cleared first before you apply? Or I know with the provisional mindset that they're just like, like the idea is to file something, if anything, at least. But in respect to practicality and use of time, how do we kind of integrate kind of the context in which this technology may be deployed in terms of the regulatory constraints of not, I guess in this case, there's, constraints related to the patent law, but how much should we bring in terms of other regulatory, like FDA is the US market. Should we be kind of creating an innovation specific to the US market, patent that, and then create a slightly different innovation that is more for the UK and then patent that? How is that typically done?
So that's a very robust question, Dan. I'm gonna try to do my best with this. So, certain things like you're saying, like certain types of applications are classified and flagged. So like one of them is called for like incredible utility. Like if you say I have a perpetual motion machine, they're like, okay, you're not getting a patent on this, and it's flagged. It's something that's not possible. So also things that are watched closely are like I have a cure for cancer using vitamin C or something like that. Or I have a cure for cancer using this, and I'm using AI or using nanotechnology, something, whatever. These things are scrutinized because, but people get patents of things like this all the time, but there is an extra level of scrutiny. As far as having, a patent examiner or the patent office is not going to cross-regulate anything in terms of FDA or HIPAA. They're going to look at it from a patent law perspective. Now, there are certain things, certain specific, we called them at the patent, when I was there, it's called like hot button cases, or they had something called SAWS, but I don't remember what SAWS is an acronym for right now, but things that you want to make sure all your ducks are in a row. You don't want to say, here's a cure for AIDS, and not be vetted. You don't want to be the examiner that issues a patent for curing AIDS, and it's something that's unproven. So there are certain things that would cause it to be kicked up a notch in terms of to make sure that it's authentic. But you can get a patent on something that doesn't have to work. It just has to mean that you cleared the hurdles of the patent office. I think the other questions you had, those are specific to your objectives. Like you have to look at what are your goals. If you want to have something in the U.S. market, then you can get a patent for the U.S. market. You're also able to do what's called an international patent application through the Patent Cooperation Treaty. And when any one of 158 countries, you can apply in the U.S. and then through the patent office at the PCT, and then that application gives you access to file that same application in any of those 158 countries. But a patent is only good in the country that it's filed in. So even though you have that international application, you still have to then file in these other countries. And that can be a very expensive process of translation, of documents, of managing foreign counsel, and all these things. So it's something that is it's a case by case basis.
In the context of patent law, right? You said they don't cross-examine. Right. Okay.
I don't want to just rule it out so they won't cross-examine, but I mean, a patent examiner doesn't know HIPAA. A patent examiner is not, even the life science or chemical engineers or PhDs that are, biotech, even if they work at former biotech companies, they're not going to apply, regulations to the patent. They're going to be focusing on what can be, and I think Peter saying this, one of reasonable skill in the art, or ordinary skill in the art. So someone who's skilled in the technology field should be able to read it and understand it and implement it. That's the threshold. And it should meet those three things: statutory, novel, and non-obvious. If it meets those, you can get a patent, theoretically. If you have a hot button topic that's, they're going to probably apply another level of scrutiny just because, they don't want to be in the news about having some, car running on water or something like that, that's not proven. So they will kick another level of scrutiny and review. But getting a patent, again, I want to iterate this, let's drive this home. Getting a patent is not the business. It's something that will protect your business if you have a business. And so you have to look at it like that. I know it can become, because of the cost of it, because of the time and resources, it's something that's very, very time consuming and resource, you're spending resources for it, but it's really just something that protects your business or whatever you're doing. And so it helps protect. It's like having insurance. It's not full protection. So I hope that makes sense.
Yeah.
Hope I answered the question there.
Yeah. Thank you, Tariq. Appreciate it.
Oh, you're welcome.
All right, this is Seth again. I think we're going to wrap now. We've been going for quite a while. So I'm about to paste into the chat Tariq's contact information for anyone who wants to follow up. And I very much appreciate your having participated today. I think that people found this really interesting based on the amount of engagement that we had. I think this is probably more engagement than we've, as much back and forth, I should say, as we've had at any of our programs. So it's been great to have you today. So again, the Maryland AI Roundtable is sponsored by TEDCO. I'm going to put the splash slide back up. Sponsored by TEDCO. and we meet monthly. If there's anyone who's not part of the roundtable who would like to join in, you can send me a note, and we're trying to open it up to more companies. We have a number of people who've been on today who are regular attendees, a few people who have come a few times. So we're really looking to open this up, and we do meet monthly. We were meeting in person. This is our second time meeting online. And then for the meetups, non-roundtable meetups, I would like to have another one in May, so I'll be looking for a speaker, preferably at this point on the technical side related to artificial intelligence and applications. So thank you everyone for joining in today. I'd welcome any feedback that you'd want to send me personally, or again, if you're not a regular member of the AI Roundtable and would like to join in, send me a note then as well. So thanks all, and I'll be seeing you all down the line.
Thank you, Seth. Thanks, Tariq. Thanks, everyone.
And I got a number of other thank yous from Jared and so on. So I'm going to end the meeting now, however. Bye-bye.